acknowledge the whole thing about how this technical issue of IP is in the end purely political, and that we feel with all the discussions that we have, it's about power. It's about who has the control over not only the knowledge resources we need for health, but also the products and the technological capacity. I mean, African countries are demanding today, we need to be able to produce our own vaccines because we're completely dependent. And our partners have just said, well, we vaccinate ourselves first, and you can wait at the end of the queue. And there is now a clear resolution. It's like, no, that's not possible. We need to have that capacity and use the technology, and technology platforms need to be shared for health. And again, there is something that health has been captured by an IP system that is designed for a totally different purpose. But this is the moment to unpack that and then hopefully come up with reform. And I don't think tinkering in the margin, but really fundamental reform, maybe not of the IP system. Maybe what we need is a reform of the health innovation regulatory and policy framework, and whether there is a role for patents in there or not, maybe not, but it will certainly not be as it is today. So for me, we need to really go to this. What is the purpose? And create something that is fit for purpose. And we see now very well that the IP system is probably not the one. I'm going to leave it there. I have many more things to say, as you can imagine, but very happy to be part of this conversation.
That's great. Thank you so much, Els. Yeah, I think it's very interesting to hear a non kind of legal scholar's point of view on this, because I think all of us are very much engaged with the researching and writing about IP issues, but I think from the outside it looks like sometimes we are really focusing on very, very small details without perhaps glancing at the larger picture of the real life implications. So thank you very much. I appreciated that. The last speaker, and I'm very happy that he's able to join. Professor Alain Pottage will speak, and he's a professor of law at SciencesPo Paris and also at the University of Kent Law School. And Alain has conducted influential research in the areas of history and theory of intellectual property, and has also written a very influential book, which was called Figures of Invention, which really traces the idea of the invention back historically and how it was incorporated in law and legal thinking. He's also published recently more on the question of law in the Anthropocene, and I'm very pleased that he's able to join us. So I hand the mic to Alain.
Thank you so much, Hyo. Thank you for convening this meeting, and thank you for that introduction. I'm going to be very brief, and in the brevity of what I have to say, I'm not going to say very much about the question of patent waivers. What I'd like to do is just share a thought that occurred to me, or rather an impression that occurred to me when I read one of the anti-waiver manifestos. Doesn't really matter which one. I think we all know which one I'm talking about, but the point is that there's a structural phenomenon here that I want to talk about, so the identity doesn't really matter. And this thought that occurred to me was reinforced during a conversation with Luke a few weeks ago. Now, you may find this hyperbolic, but when I read this particular manifesto, the thought that occurred to me, or rather the figure that appeared really clearly in that text, was the figure of Adolf Eichmann. You might find that hyperbolic, as I say, but the Eichmann I have in mind is the Eichmann of Donna Haraway. I just want to read, this will probably take up most of my 5 minutes. I want to read the short section from Donna Haraway. Arendt witnessed in Eichmann not an incomprehensible monster, but something much more terrifying. She saw commonplace thoughtlessness. That is, here was a human being unable to make present to himself what was absent, what was not himself, what the world in its sheer not oneselfness is, and what claims to be in here in not oneself. Here was someone who could not be a wayfarer, could not entangle, could not track the lines of living and dying, could not cultivate responsibility, could not make present to itself what it is doing, could not live in consequences or with consequence. Function mattered, duty mattered, but the world did not matter for Eichmann. The world does not matter in ordinary thoughtlessness. Now, as I say, you might think that is hyperbolic, and of course for Haraway, we are all in some sense the descendants of Eichmann. But the point I want to make, and the thought that occurred to me is quite simply this: that what is on display in these texts is a kind of ethos, a habitus, an ethos that is inhabited and in some sense enjoyed, if only in the psychoanalytical sense. And I think beyond the question of who is right or wrong about how patents work, it is that ethos that is on display that in a sense should be the object of analysis and critique and intervention. And so my proposal would be that we think about what is it about the architecture of IP, and particularly patent law, as Lucas suggested. What is it about the system of IP? And we keep talking about a system that generates the positions that that kind of ethos fills out, or that generates people with that kind of ethos. So that's all I have to say, and I could say a lot more about it in the course of discussion. So maybe we'll get to that. Thank you.
Thank you very much, Alain. I think if I may just comment on that briefly and try to tie it back with some of the points that others have already raised. I'm kind of thinking whether purely formalist analysis of patent law as applied and supposedly analyzed in very sketchy terms, and still published in those terms, has something to do with the fact that, first of all, that certain patent legal methodologies assume epistemological superiority, which cannot be scrutinized in other ways. So, for example, not by interdisciplinary methods, not by reference to ethical demands, not by reference to what it means to value health, for example. And whether there is a clear link between the ethos of the IP scholars with the kind of the preferred methodology that they choose to take and the blindness that it necessarily entails by not looking at other forms of knowledges. So I think it kind of goes back to what Fiona was saying about how methodology is already a choice, which is inherently political. But yeah, thank you so much. That was very thought-provoking. And I would like to invite the panelists to comment on any points that you found interesting that you want to return to. And then I would like to open up the floor to questions. So let me just see if I can switch to gallery view. So Els, would you like to say something?
Yeah, maybe one thing that I forgot to mention also in my presentation, but referring also to quite a lot of what the others have said, is a lot is about narrative and the words, and Fiona, you mentioned that the methodology, but for instance, I mean, just the fact that we talk about intellectual property rights. I mean, both the right is a problem and the property is a problem, but that is and this is being exploited. I mean, if you try to say, well, you need to share technology instead of keeping an exclusive monopoly, the reaction is you're stealing something from me, and it's like, well, wait, no, but that's because the word property is ingrained in people's minds, and then that it's a right. I mean, I was at a panel recently in the Belgian parliament, and there was, I don't know where they found this man, but I mean, it was a professor of intellectual property right in I can't remember, somewhere in Belgium. And he was saying, well, it's this intellectual property rights are and it was about the waiver, obviously. And he was saying intellectual property rights are part of the human rights. And I was like, where did he find that? I mean, this is what professors say in a public hearing in the parliament. But I think a lot about language. I mean, stronger. We talk about stronger intellectual property rights are better. Like, wait, where does that come from? And there is no empirical evidence for that. Well, in contrast, there is actually quite some evidence that it becomes it becomes a gatekeeping issue, the governance of that. You restrict access, and so I think that a lot of the language needs to be changed, and then you can have a different framing of what you're actually trying to do. But now, I mean, I feel that the whole health area, as we've been captured in a certain way of thinking, and yeah, as Alain, you were also referring, that this is the way that people that believe that this is the right framing works. But that is a winner takes it all capitalist system, and I mean, and that does not for health apply or shouldn't apply. But that's where we are caught. Anyway, wanted to emphasize the narrative.
Thank you. Fiona, you raised your hand.
Thank you, Hyo. So, of course, like every other IP person probably here, I'm so delighted to hear Els' response to this question: intellectual property rights are human rights. Because what I want to say for perhaps people who don't know this is, when I go around the place and say, this is the worst, most anti-intellectual, regressive position that can be taken, my colleagues in law regard me as a complete lunatic. Okay, so this is one of the reasons that we're, because they say, look, in the European Charter of Human Rights, it's clear that property is a human right, intellectual property is property, ergo intellectual property is a human right. And my response to that is that, well, the European Charter of Human Rights is wrong. And that's a thing which is very hard for legal academics to say, that in a sense, and that's because we have this idea that the law is there. We can't change it. It must express some political or divine choice within which we have to work. And I would also locate other discussions. There's so many things I could say about these fantastic presentations that I can't really say them all now. But I would also locate other discussions that we have around the question of the waiver, around the question of compulsory licensing within this same problematic framework. I agree that politically we should support the waiver because it's a way to save lives. Okay, that's why I agree with them. But I also think that there's some dangerous way in which, by supporting these types of initiatives, by saying that there should be compulsory license, whatever, that we're just giving more authority to the law instead of saying the law is just wrong here, it's bad. Intellectual property, and I think we need to look at, so, this approach of trying to say, let's balance intellectual property with human rights, well, it's not going to take us anywhere. I mean, it just takes us into a minefield of kind of misunderstanding. So I think we need to also be very careful with this idea that we can't change intellectual property. I mean, I think we should be looking to change it. I think we have to say property rights only have valence and importance in a market. And as soon as you introduce property, and I'm not talking about personal property like your clothes, I'm talking about transmissible property rights. As soon as you introduce them anywhere, then you introduce market thinking. Okay, and it's defective market thinking. I mean, Luke made some wonderful points. This idea that the market is a defective market. It can't operate. It doesn't operate well. It needed massive state funding in order to operate, to produce vaccines in this case. So what we have is public funding and enormous private profits. Okay, so we're in a situation where we shouldn't allow ourselves to get caught inside what the law tells us is there. We also need to be able to say the law is wrong. The political and ethical choices that were made by this law is wrong. I think patent law is very problematic and dangerous precisely because it's so technical. And Luke also put his finger, all the presentations were wonderful, but Luke also put his finger on this, that the technical is much harder to address politically, okay, because it belongs to an elite, okay, and that's harder to address. Now, I think that's also true about the bureaucratic, and that in some sense is Alain's point. Okay, what was Eichmann? Icahn was a bureaucrat. Without his bureaucratic brilliance, the final solution wouldn't have happened. Okay, not a very good reflection on bureaucracy. But I think that we have to understand all those areas as being areas where we can intervene politically. Okay, that's, I could, like a bit like Graham said to his, I could go on about this for ages, and I won't keep going. But thank you very much for these great interventions.
Graham, do you want to go ahead? You're on mute, Graham.
Sorry, thanks. Yeah, as thank you, Hyo. As somebody who is sort of late career on the wrong side of age 39, and given that a lot of people here in a quite early career, I think I feel obliged to say that spending time on this sort of policy engagement and being interdisciplinary is not done without paying a price. All right. And it's important, you might as well know what the price is. So one thing, I made a whole list of ways of things, processes that I have been particularly engaged in, a whole list of them. I won't bore you with them. But that's according to, heads department and heads of research and ref reading groups. That is time not spent on an MLR review, on an MLR article, and therefore is a waste of time. None of what I do would form an impact case study. Being interdisciplinary is something that our ref reading group simply does not understand, right? So I mean, I'm completely frank about this. I've had 1 3-star in 2 ref cycles. Everything else is 2, right? My work means nothing to my department. It means more my university, but I guess it has some kind of wider interest. I've been advised to stop working on my textbook with Uma Thurston on the global IP law. I was advised, no one, it's a waste of time writing textbooks. My pharmaceutical industry book, I was advised to stop work on it and write an article instead. Unfortunately, other universities are run by these bean counters, and they will be very, very dispiriting at times. So that's very frank, honest, anecdotal. But what I'm saying is, I'd love you all to have your careers in the way I have. And look, I'm happy. I've been lucky, and I enjoy life, right? But I'll say, there are prices that I've paid. So just wanted to put that out there. Okay.
Séverine, would you like to join in? Hello. Nice to see you.
Hello, everybody. I'm sorry, I came in late because I had another meeting.
Great to see you.
Thank you. Not as interesting as this one, unfortunately. So and I'm sorry, so I haven't heard most of the presentation. But I would like to come back on the human rights issue, and also, and I think that what really amazed me in all these reactions about the patent waiver from IP experts and I know about what happened in Belgium and this testimony that patent was a human right, so there was no way that it could be defeated or taken away. I think that most of the expertise is really coming from a very strictly national viewpoint, where the economy of patent is always thought as, we have a patent, it's good for innovation, and we will deliver. But actually here the issue is global, and in these statements against the patent waiver, there is so few things about the global dimension of the issue, about the fact that the economy of the patent might be completely different from the north to the south. And I don't have any problem with the patent being waived in the south, but being enforced in the north. We have the money we have the market, an efficient market to buy vaccines, etc. Anyway, it is paid by public money in so many ways that, but I think that there is really this global dimension is completely missed in the debate, at least on the side of those defending strongly the patent. And it has a link with the human rights issue, because there is this very good paper by Ruth Okediji about human rights in IP. And she said that actually we don't need human rights in IP, because it's really a wrong strategy if we think IP as a global good, because individual rights, and this is a long paper, but in a nutshell, one of the arguments is that human rights are mostly individual creatures, individual Western creatures, and it's very difficult to enforce them collectively. So having a population claiming the access to medicines as human rights is really, really difficult to oppose to intellectual property as an individual human right that is very easily to enforce because it's an individual exclusive property right. I don't know if I make myself clear, but there is this asymmetry between access to medicines, for instance, as a human right that should be enforced collectively and has a global dimension, to conceiving and it's in opposition with the IP patent as a human right that would necessarily be an individual property right. So it's not possible that it could be reconciled or balanced together in a way, So this is because we talked about the human right, but you might have talked about that before. I'm sorry.
I think it's you were not repeating points that were previously discussed. So thank you for that. But I was just wondering, patent rights as IP rights. We know that IP rights are not the same as, land law, like the real property rights, etc. And they were always circumscribed with a certain purpose and with a certain limitation that they should serve the public good, or that they should, for example, promote innovation. And of course, we can argue about what the definition is of innovation that we're talking about here, because often innovation is defined circularly by reference to number of patents filed, right, or number of patents quoted. So I think that's an interesting issue. But I do really have conceptually, I have a hard time understanding IP rights as human rights. They might be rights, legal rights, but we might be able to distinguish legal property rights from human rights or international human rights. Just my incomprehension of equating IP rights as human rights, but others might disagree. I would like to just briefly pick up on a point that Charles Oppenheim has made, which I think is a really important point. I think so. I'm just going to read out his comment. 2 points. Firstly, although the panel have identified the problem with legal analyses of intellectual property rights, they have said very little about how to change the way researchers approach their work. And then second, he has also mentioned about the importance of copyright. And I think Luke has, thank you, Luke, for addressing part of that comment. But I think it's something that I would like the panelists to think about what you think, how we could change the way we approach our work, and also how to distinguish that from some of the more problematic, I guess, formalist or dogmatic black letter law analyses of IP law that we have seen in some recent publications in relation to the TRIPS waiver. It doesn't have to be related to the TRIPS waiver, but I don't know how I think we all teach in different ways. Sometimes we teach doctrinally, sometimes we teach most contextually. Who would like to take this question? Thank you, Fiona. Fiona?
Here I am, sorry. Actually, I think Donatella, I don't know if she wanted to reply to this question, but I know she had her hand up. So maybe before trying to say something in relation to Charles' question, Donna might want to come in. So
perhaps it was related to this question, because I was thinking about the point about methodological choices, but also about ethos. We could say perspective of seeing as well, that we make, even though we say, we might say we don't make. And I wonder what kind of choices would be needed then to enable the IP activism that we started with, saying there is very little of. So I guess it is related to Charles' question, because I wonder, what kind of choices we would need to make as scholars in order to make a very different kind of intervention. And I know many of you have made this critical intervention for decades now. And the waiver has been the catalyst, but also what kind of alliances might be able, to sustain this moment for not just the vaccine and the TRIPS waiver, but for keeping the pressure on the assumptions that IP law makes. And I think there was another point that Zainab was making about also manufacturing capacity. So how to link with perhaps other scholars who are looking, at the need to, to complement efforts on the waiver with transfer of technology, ensuring, supply chains, redistribution of materials, and so on and so forth. So I guess the question is, what kind of methodological choices we could make, collaboration and alliances that enable the kind of IP activism that you were, trying to foreground here. But it's a question for everybody.
Fiona, would you like to take that, or is your comment related to what Donatella had said?
I'm not sure, which it kind of goes back to the question Charles, it's related to what Donna said, it goes back to the question Charles raised, and it goes back to something that Graham said, but I think is really interesting. Okay, he said, that he's not against scholarship for its own sake, and that he doesn't tell his students what to think. A scholarship for, when, perhaps Graham can say something about this, but when someone says scholarship for its own sake, I'm thinking that you meant, Graham, that people, because you referred to the famous ivory tower, something I'm afraid I've looked for my entire academic life without any success whatsoever. But anyway, but perhaps that scholarship for its own sake is a better distinction between scholarship and activism in a more traditional sense that we have to think about. I mean, they're important. Not everybody has to be an activist like Graham. It's great that people are activists like Graham. That's not everybody's cup of tea, and it's not everybody's contribution. And being an activist not the same thing as being political. I think that's a really important question that we have to engage. Activism is one way in which political strategies are carried forward, but political strategies also need to be planned and they need to be theorized. And so sorry, this is a real, off the sort of not well thought out position. Sorry, I've thought about this a lot. So in some ways it's well thought out. I come from a tradition of critical legal theory, which 20 years ago was regarded as a complete outlier in scholarship, complete outlier. So the people that did it were regarded as complete lunatics. Okay, that is now a mainstream tradition in legal thought. So what this tells me is that, and people don't laugh at you when you go and you take critical legal theory positions. So what that tells me is, okay, yes, we need scholars who are activists who will go and take the fight out into political, but we also need to lay down a theoretical agenda where we keep going to places where we might not be welcome, where we might seem a bit mad, and we keep saying these things. So I know if I was giving a seminar somewhere else, not here, but somewhere else, and I said the things that I said about all choices being political, about black letter, that lots of people would regard that as really difficult, and perhaps there are people here as well. But there's not a magic bullet for this. The way that you convince people that you're right and they're wrong because of the results because of what we see around us, is to keep telling them that, is to keep going and to keep communicating with people. I haven't really got another solution to it. Okay, so that's it.
Thank you, Fiona. Luke, did you want to come in?
Yeah, I just wanted to say something very quickly, especially to any kind of younger scholars or even students that are on the call, some names I don't recognize, which is, one of the things this crisis has taught me is that you should always be extremely wary of anybody who says to you, you don't understand because this is too complicated. And we're constantly hearing that from people in the pharmaceutical industry. And the more questions that have been asked over the last month since the waiver debate has kind of ratcheted up have revealed a lot of fallacies that were stated. The fallacy that there is no capacity, or it would take several years to build more capacity. These have been debunked because journalists started asking questions, and they started asking questions like, how did Moderna build its capacity when it had none this time last year? Or what about the companies that have offered capacity, including huge companies like Teva, and have been rebuffed? So, keep asking questions, and I know it's a bit of a cliche, but try to be encouraged and have courage in asking those questions. And, believe me, I've gone down the rabbit hole of technical patent law, and it is not as obscure as it seems, in all honesty. You probably do have something useful to add to this debate. Even if you don't understand every single technical element of the process, you can still understand some key essential points, in the same way that, for example, Els' input is so valuable. Even though she's not a lawyer, she still understands some of the key elements of what is happening when an IP barrier emerges. So that's really all I wanted to say in that regard.
Thank you very much. I think for me, what's really interesting is to see how all of us actually have worked in different ways, either historically, theoretically, critically, more policy-oriented, activist, focusing on specific areas. But I think all of us, in a way, have always questioned the fundamental assumptions underlying, or the fundamental concepts underlying IP law. And I think that's the main difference between people who study IP law from a mainly law and economics point of view, because then you just kind of try to map out empirical evidence based on models and some historical data to legal rules. And I think that's something that kind of two-dimensional thinking is something that we've all resisted in a way, but it's very hard to convey that necessarily within the quite structured law school curriculum. And I think we are all struggling to make space for that kind of pedagogy. So that's something I think which we all probably are facing at the moment, and will also face increasingly in the future, depending on the education system that we work in. But I think our time has unfortunately ended, and it's been actually 1.5 hours, which passed by very quickly. And I want to thank you, all of the panelists, very much for taking time to participate in this conversation. I hope you enjoyed it, and I also hope that we found some new allies, friends, and colleagues with who we will stay in conversation with. So thank you all very much. And I will send around the link to all participants once the recording is uploaded and is available. So thank you very much.
Thank you.
Thank you.
Thanks, Hyo.
Thank you very much. Bye.
Bye.
Thank you. Bye.